Hello, everyone, and welcome to our first episode of Lunchtime Legal Talks. We're excited to have you here today, and we'll look forward to having a great and nice discussion with our guest and with every one of you who are here. Our topic for today is shareholding. Anyone who has had any dealings with the workings of an incorporated company or who is in the know of issues relating to the estate of a disease worthy person has probably heard about shares. And although the word share can make one think that the holder owns a chunk of the company, the ownership of shares in a company does not mean that the shareholder has a share in the property of the company. The company's property is owned both legally and beneficially by the company, and the shareholders are not joint owners of the company's property. The shareholders don't even have equitable interest in the property of the company. And this is why, in a situation where a shareholder, in a bid to protect their investment in the company, tries to take up insurance on the properties of the company, they are always held not to be able to do that. The company whose shares form the subject of shareholding is a separate corporate entity that has its own assets and liabilities. The shareholders are separate persons, and from their status as shareholders, they have no relationship to the company's properties and debts. The company itself is treated not merely as a person, which is the subject of rights and duties, but also as a res, the object of rights and duties. And as one commentator puts it, it is the fact that the shareholder has rights in the company as well as against it, which in legal theory distinguishes the members from the debenture holder, whose rights are also defined by contract, but are rights in the company. And if the debenture is secured in its property, but not in the company itself. The shareholders have statutory rights specified in statutes such as the Companies and Allied Matters Act and the Investment and Securities Act. They also have contractual rights against the company and against other shareholders as expressed in the Articles of Association of the company. Shares are a type of interest referred to as a choice in action. And a choice in action is a non-legal expression used to describe all personal rights of property which can only be claimed or enforced by action and not by taking physical possession. By being a choice in action, a share is a piece of personal intangible property which can be owned, bought and sold, mortgaged, and will form part of the estate of a deceased person. Shareholders have rights and obligations, and one of the obligations which shareholders have is to pay the amount of the shares they hold. This obligation is inherent in every issue and lies on the shareholder, even when not stated in the articles of the company or the terms of issue. Once the payment is made, the obligation on the shareholder is done. Nothing else is required of him, and he is even at liberty to vote against the interest of the company at meetings. The rights that attaches to shareholding are the right to attend any general meeting and to vote at such meetings, the right to dividend when declared, and the right to participate in distribution of assets in the event of winding up of the company. One major incident of shareholding is that it comes with the power of control over the affairs of the company. Through their control over the articles of association, the shareholders have extensive control over the shape of the company's management. They also have control through the right to elect or remove directors. They can veto a merger or the sale of corporate assets to third parties. They can exclude directors, third parties, and other shareholders from their property through various types of judicial remedies. One one popular one is the action against directors for breach of statutory or common law fiduciary duties. For one to become a shareholder in a company, he has to acquire the shares of that company somehow. And there are four ways of getting to become a shareholder. The first is by subscription to the memorandum of association of the company. at incorporation. The second is allotment of shares by the company. The third is transfer from one or more existing shareholder to another or new shareholder. And the fourth is by transmission by operation of law. In the process of incorporating a company limited by shares, the Companies and Allied Matters Act requires that the members subscribe to the memorandum of association of the company. And those initial members are required to take up between themselves all of the issued share capital of the company. Upon doing that, the subscribers become shareholders. From time to time, a company may need extra resources and funding. And one of the ways to do this is to issue new shares and allot them either to existing or new shareholders. Shares may also become available for allotment when the shareholder surrenders the shares to the company. Ordinarily, the powers to allot shares is vested in the company acting through the general meeting. But this power can be delegated to the board of directors either by resolution of the general meeting or by the articles of association. The procedure for allocation of shares will depend on the type of company in question. For private companies and public companies not listed on the stock exchange, it is that first the prospective shareholder sends a written application to the company and indicating the number of shares he wants. The company then considers and decides to either accept wholly or in part or refuse. If it accepts wholly or in part, it will allot the shares to the applicant and notify him within 42 days. For a public company listed on the stock exchange, the Companies and Allied Matters Act refers to the Investment and Securities Act and by extension the SEC rules for that. We'll leave this procedure out for a future time when we talk about capital markets for an in-depth discussion. An applicant awaiting allocation can also withdraw his application at any time before the shares are allotted. After allotment, there's a regulatory filing obligation on the company. And by this obligation, the company has to notify the Corporate Affairs Commission of the transaction with relevant particulars within 1 month after the allotment. The relevant date here is the date of allotment and not the date of notification of allotment. Following the coming into force of the 2022 Companies and Allied Matters Act, companies no longer have the option of having part of their capital unissued. So, except the shareholder surrenders his shares to the company or the company buys out a shareholder, it will not be able to allot new shares. When the company then needs new capital, what can it do? One of the options would be to issue new shares and allot to existing or new shareholders. Shares can be issued at the nominal value or at a premium, but never at a discount. A share is issued at a premium when the value at which it is issued is higher than its nominal value, as indicated in the Memorandum of Association of the company. For example, assuming the nominal value of the share in the Memorandum of Association is 1 naira per share, and the price of the shares issued is set at 10 naira per share. That will mean that the shares are issued at a premium. When shares are sold at a premium, the excess of the nominal value is placed in a share premium account, and those funds can be used for paying up on issued shares of the company, which will then be issued to the members as fully paid bonus shares. It can also be used for writing off preliminary expenses of a newly incorporated company, used for writing off the expenses or the commission paid on any issue of shares of the company, or providing for the premium payable on redemption of any redeemable shares of the company. Issuance of new shares in a company will definitely dilute the shares of existing shareholders, thereby reducing the percentage of their shareholding in the overall company structure. This will have the effect of reducing their level of control over the affairs of the company and to forestall a situation where directors or majority shareholders take advantage of the power to issue new shares and reduce the influence of particular shareholders. The Companies and Allied Matters Act requires that when new shares are issued, they cannot be allotted unless they have been offered to existing shareholders of the class being issued in proportion as nearly as may be to their existing shareholding. This offering has to be by notice specifying the number of shares the shareholder is entitled to subscribe the price of the share, and the reasonable time frame for the acceptance of the offer. It is only after this period elapses or the shareholder informs the company that he does not desire to take up shares of those that have been allotted, that they can be allotted to a third party. After this offering is made, the shares cannot be sold to the third parties on less favorable terms than those offered to the existing shareholders. When shares are allotted, they are allotted at a price, and there has to be payment for that price. This can either be by cash or non-cash payment. Cash payment is pretty straightforward, like transfer money to the company's account or write a check in favor of the company for that amount. But in cases of non-cash payment, there has to be valuable consideration flowing from the allottee to the company. And before that can happen, the company's articles must have provided for that. So talking about valuable consideration, the approach to determining this is different between private and public companies. For private companies, so long as the directors, in agreeing the terms of the contract of allotment, are genuinely and honestly of the view that the company is receiving property or services of the same value as the nominal value of the shares, the allotment stands valid. But of course, if it is clear from the face of the agreement itself that the company is to receive less than the nominal value of the shares in return for an allotment, and the directors could not possibly have been on the view that the company was receiving property of equal value, then the allotment will not stand. That's for private companies. For a public company, it is a different ballgame. Valuable consideration is not left to the directors' honest belief, and the company will have to appoint an independent valuer to determine the true value of that consideration. It is based on the independent valuer's report that a decision can be reached whether or not the consideration is one upon which the company can issue those shares. Subscription and allotment are means of acquiring shares from the company. But since shares are personal property which can be bought and sold, transfer and transmission are the ways shares move from one shareholder to the other. The issue of shareholding is really, really deep. And to join me in this conversation today are my learned friends, Max Ikongbeh. Max Ikongbeh is the principal of Ever Law Associates, an Abuja and Lagos-based law firm. Max, you're welcome to the show.
Thank you very much, Mordecai. I hope you can hear me clearly.
Yes, I can.
Thank you.
And
It's
then
a
also
pleasure to be
joining
here.
us is Imisioluwa, Jemisenia. I hope I got the name right. I've always struggled with your name for how many years?
All right, everybody wonders it, but it's a pleasure to join. Correct
All right.
pronunciation, Jemisenia. Let's
Okay,
make it to
right.
be able to pronounce it
I won't try to repeat it now, so I don't get it
Right,
wrong
I
again. I'll
understand.
just stick with Imisi for the rest of the show. All right.
It's a pleasure to
So,
have you,
well,
Sir Max.
Yeah, thank you so much. It's a pleasure to join you to discuss this important topic as well.
Yes, thank
all
you.
right. So, let's talking about the concept of shareholding in corporate law class. Everybody, when we're talking about this concept of shareholding, how a shareholder is different from the company, we all go back to Salomon versus Salomon, right? Max, let me start with you. What's your take on what shareholding has become? The concept of the shareholder being different from the company and they're not having interest in the right. What's your take on that?
Thank you very much, Mordecai. I mean, and your summary at the beginning of the session aptly captures it. When it comes to shares, particularly for people who are not lawyers, I know it can be a little daunting to wrap your heads around such a crazy concept. I mean, because you have somebody before you in flesh and blood, he comes to you. I mean, I'm alluding to the popular case of Solomon and Solomon. You have somebody who comes to you in flesh and blood. It's Max Ikongbeh. You know him. He says, "Look, give me a loan. I want to use for my business." But he takes the loan papers, he signs them in the name of Marx Ikongbeh and Company Limited. You give that loan to him. 2 years down the line, Marx Ikongbeh does not pay you. You repay the loan with the interest. And then you come to seize his car because you see Marx Ikongbeh driving a Cadillac or some luxury car, and you come to seize that car to get your payment back. And strangely, Marx Ikongbeh tells you that, look, you can't take this car from me because this car belongs to Marx Ikongbeh that you see. But the loan you gave was to Marx Ikongbeh and Company Limited. And Marx Ikongbeh and Company Limited is a different person in law from Marx Ikongbeh, the man you see before you. Of course, to the person who is not a lawyer and is not familiar with the case of Salomon and Salomon, that's arrant rubbish. Who's going to say, look, stop that nonsense you are saying. It's a simple matter. I gave you money and you have refused to pay me. So therefore, I have the right to take your property, your car, which I can see, in return for that payment. So I'm just setting this elaborate background because I believe some of the people joining us this afternoon might not be lawyers or are not familiar with the case of Salomon and corporate law principles. But as outrageous as the story of Salomon and the story I've just related sounds, the law has created that room. I mean, there's justification for that, and I believe at some point we get to that. But the basis of all I'm trying to say is that looking from Salomon up until today, the principle of corporate personality, which is also, of course, what shareholding is based on, is a principle that you have to approach with that basic mindset. That in law, the law creates what we call a legal fiction. Legal fiction simply means that a company is different, so far as the law is concerned, from the owners of the company. And the only connection between the owners of the company and the company is the shares that they own in the company. And good enough, your summary at the beginning, Mordecai, very well defined, and explained clear that when you hold shares in a company, the shares you hold is in the company. And like we've said, the company by legal fiction is an entity or a person. Of course, not a human person, but what we call an artificial person. So what the shares you own is in the company, not in the assets of the company. So you cannot say, for instance, that because you own shares in Dangote Cement, if you see a truck of Dangote Cement, you say, oh, I own 10% of the shares in Dangote Cement. Therefore, 10% of all the cement loaded in that truck belongs to me. No, it doesn't happen that way. Or 10% of the truck belongs to me. Your shares entitles you to a part ownership of the company, not a part ownership of the assets in the company. So these are, little distinctions, like I said, that sound outrageous, but because you need to understand that, the law created a fiction and the law has to back up that fiction. So, I mean, like I always tell people, when you write a fiction novel, a novel that is a work of fiction, there's a plot, there's an end game you have in mind in writing that novel, but there are justifications or, that lead to the build-up of the plot. So there's a lot more in the law of shareholding, like you've mentioned, that now explains and justifies, this legal abstraction where you create a separate person in law from, the owners of that person. Thank you, Mordecai.
Welcome, Max. That was a lot of jurisprudence. Imisi, from a legal standpoint, does this concept of shareholding, saying that shareholders have no interest in the properties of the company, does it make sense to you?
Like Marx, just please permit me to refer to him by his first name. Like Marx just explained, the company is a separate person from its promoters, its shareholders, directors, whoever works with it or for it. So the company holds its property in its name, right? What the shareholders have as shares in the company. So, like you rightly explained, were the company to take out a loan, right, you would only be able to move against the company to recover your loan or the assets of the company to recover your loan. While shareholders hold shares in the company and the shares are attached with rights, restrictions, such that, the shareholder can benefit from the property, assets, income, profits generally of the company it's not a direct ownership, right? So the shareholders do not own what the company owns. The company is seen in law as its own person. It can speak for itself through its directors. So if you were to move against the company to recover your debt or anything, you'll be moving against the assets of the company. However, when the assets of the company are insufficient to, you know, liquidate the debt, then I mean, you're looking at winding up the company and then selling off the assets on what do you call it now? Yeah, according to a hierarchy. If you get what I mean. So the creditors first, then the shareholders, depending on their classes of shares, and sometimes the shareholders go home with nothing or less than what they put in initially, right? So, and if at the end of the day you've moved against the company and you're not able to recover your full sum, it's a sad tale for you. I mean, there's nothing else anybody can do for you. The shareholders are thus insulated from any actions against them personally. What they lose will be whatever it is they've invested in the company, but nothing beyond that.
So that means it makes sense to you. All right. So talking about that, there are basically two types of shares, or more than that, though. But then we have ordinary shareholders, which are shares that don't have any special rights, and then we have preference shareholders. Some people have said that preference shareholders are more like preference shareholders are more like creditors than actual shareholders. And then somebody said that they are somewhere between ordinary shareholders and um, debt financiers. So, Imisi, I'll start with you on this one. What do you think about preference shares? Do you think that the incidence of their own shareholding, you give them any kind of right in the company's assets somehow? Maybe not directly, but by implication.
The foremost benefit of the preference shareholder is that in the incidence of payment of dividends, you get paid first. If there's a liability, because you see, as shareholders, the first thing is actually your liability, not not what you benefit. As shareholders, your liabilities come first. When you defray your liabilities, then you're looking at what you take home, right? So and then in the event of, for instance, a winding up where everything is going to be defrayed, what's going to be left over, if there's anything left over? The benefit of being a preference shareholder is that you're preferred to the other classes of shareholders, such that you get a portion, you get, paid off in the winding up process before any other class of shareholders, say the ordinary shareholder, right? So that's what's foremost. So I wouldn't say the preference shareholder is like a creditor, because in any case, creditors, according to their classes, will come before the preference shareholder. It's just that the preference shareholder ranks above the ordinary shareholder.
All right. Thank you so much. So, Marx, talking about types of shares, founders' shares is a share that a payment of dividends and return of capital to them comes after that of the other classes of shares. What's your take on founders or deferred shares?
Yeah, thank you, Mordecai, for that. Yeah, so class of shares has become a very important topic in recent times, particularly in Nigeria, because of the boom we're having in the fintech industry. So it's a great tool, and I particularly like it because I believe it's a great tool for protecting and supporting innovation and supporting startups. Because invariably, what you have happening is that when it comes to corporate governance and what, I'm sure Nimisi will tell us more about, or he wouldn't want to talk about it, but we want to talk about what we call a boardroom politics. Now, boardroom politics and those things happen because there's a lot of complexity when it comes to shareholding, corporate governance, and how you run a company. So invariably, people who are more experienced in this field have an edge over people who might not be very experienced but are innovators. So classic example, I mean, in the technology sector, for instance, you have young guys like Mark Zuckerberg who got out of school, had a brilliant idea, wanted to start a company. But the idea is that if there were no protections in law, such as one of which would be, the protections, the hedge around founders' shares, then he's going to have himself start a company, and then he's, running that company with people who have a lot of knowledge and are very savvy in corporate matters, in shareholding and all of that. And it will be very easy for him to get schemed out of his company. Now, when that happens, two things are happening. Number one, you are disincentivizing innovation. So it means for the young person who has a brilliant new idea, he knows that if I execute my idea and start up a company, I have no protections. I could easily be edged out of my company. So that is on one level. On the second level, what he also does is that in a long term, for any economy that this is not properly structured, you now make it so that the hawks, who are the people who can prey and and are the predators, would now gain the upper hand to a point where there's no new innovation in the system, and then to a large extent, your economy begins to cannibalize itself. So there's really no forward movement in terms of your corporate environment in your country. So when it comes to founder shares, one of the good things it does, and which is what I encourage a lot of fintech startups really understand and use to their best benefits, is that it ensures that as a founder, you have certain rights that go beyond just that of an ordinary shareholder. And like you mentioned, Mordecai, typically we talk of ordinary shareholders and preference shareholders just because those are the easiest boxes to categorize it into. But with founder shares, you can keep a lot of benefits. So you could put things, for instance, like you put extra benefits for them in the shareholders agreement, which is usually where it makes sense when you have founder shares. You attach those rights and obligations to the founder shares in the shareholders agreement. So you could put a lot of things, simple examples, things like extra anti-dilution provisions for them. So if the company is suddenly going public or there's new capital flowing into the company, then the founders, would be entitled to get certain shares on a vested basis, what we call sweat equity. So we say, look, we know that what you have given to this company is much more than just much more than just your time. You have given also a lot of your sweat over time. You have thought through the process of setting up this company. So you could put some of those extra protections into the founder shares to ensure that the founders are able to have some control over the company, even when the company becomes successful and begins to take on a lot more capital and lots of new inventors. So for me, I like founder shares a lot, and it's something I encourage particularly fintech startups to understand and use to their advantage as much as possible.
Thank you so much, Max. I like the fact that you said you like founder share, but you made it sound so attractive for the founders. You didn't tell them that every other person is going to take preference over them, and if the company fails, they are most likely going to be the ones to walk out with nothing.
No,
That
that's only natural. That's only natural and proper.
That is the part you left out.
Well, true. So as you enjoy it, also remember that there's the risk. So it's just like we say, you have to take the the sweet and the bitter together. So just the way you enjoy it, if things go wrong, and it's only proper that if your company flops, you should be the one to take the whole brunt, because if it succeeds, you're also the one getting a lot of the benefit. So if you also fail, you should get a lot of the blame as well. So I think it's balanced and fair, but I agree with you that I left that out. So it's good to sound that note of warning.
Imisi wanted to add something on the founders shares.
Oh no, I was just highlighting what you were highlighting, that at the end of the day, in terms of rights and benefits, liabilities, they are at the bottom. In fact, because they are at the bottom for their benefits, they are at the top for their liabilities, right? Because when it's time to then liquidate, dissipate, distribute whatever is left of the total assets, you're the last to get whatever it is that's distributed. I'm having power issues on my side. I hope it's not causing any breakup on your side.
No, we are seeing you clearly.
All right, great, because I can't see myself. All right, so that's just what I wanted to add. They are deferred shares. They are deferred to the last. They are the last in consideration. So it's good to also hold that in mind. I think there are questions in the private chat as well, in case you want to start taking them, or maybe later.
Okay. We'll get to the questions later. You know, a commentator once created a scenario where somebody invests $400,000 in a company, and then he brings the 400,000. A founder has picked a brilliant idea to him, and then next week the company is folding up, and then because the company is folding up, he just had 50% of the assets of the company. Then the founder can walk away with $200,000 for doing nothing in 1 week, and this person loses, and then the investor loses $200,000 because of course
I
they
think
did
the
nothing, and then the company just
yeah, I
and
think
then
the investor had a bad lawyer.
in a case like that, the founders share will definitely protect uh the investor. All right. So let's go on. Let's talk about bearers share. The Companies and Allied Matters Act has outlawed bearers share. Do you think it could serve some use for us to have it, or you think we're better off without bearers share, Imisi?
Okay, I was going to defer to Max. I think the state of the law as is, to my mind, is fine. There may be benefits to having bearer shares, but the cons are also, I mean, when you think about money laundering considerations, maybe tax evasion and stuff like that. You know, these things make it not attractive to government to allow for bearer shares. And that's why maybe we have tax havens. You find that in most tax havens, bearer shares fly. These things happen. What you just need to have is to bear the shares. I mean, maybe with no name. You just go and present the shares to say, I'm the bearer of the shares. So it allows for a lot of things to go under the radar. So for that reason, I'm on the side of the government with this one, right? We are better off. Let everybody know who owns what your contribution to society is, what it should be, the basis of determining it, and so on and so forth. What's more, the newcomer now allows for single ownership of 100% shares in the company. So if the intention is to be the sole holder of all shares in your company, then you're allowed to do that under law now, and that allows you, to stay within the view of governments with relation to, KYC, tax considerations, and your other obligations to the government under law.
All right. Thank you so much. Now I want to talk about the transfer of shares. I understand that when parties want to move shares from one shareholder to the other, it's usually by way of transfer. The shareholders are supposed to provide an instrument of transfer to the company, but then something very crucial happened in the newcomer. Now, there's no requirement to register share transfers anymore. Not only is it that there's no requirement, there's no procedure for registration. So shares can be transferred between different people. As a matter of fact, the original founders of the company can actually transfer their shares to other shareholders, leave the company, and then there'll be nothing on public records to show that this change has happened. Now, I see I see that there's a problem there. I see that there's a problem. I understand that some people are trying to come up with a way whereby the shareholder will relinquish the shares to the company, will surrender the shares to the company, and then the company will allot it to the fresh shareholder. But then there are problems there. First of all, from an accounting perspective, these shares that are sold are supposed to reflect in the books of the company. And if they don't reflect in the book of the company will have questions to answer. The directors will have questions to answer. Also, for the shareholder who is selling their shares, assuming this shareholder is a is a foreigner and wants to move the proceeds of the share out of the country, he's going to face regulatory hurdles at that point. What do you, starting with Marx, do you see this as a problem? And if you think it is a problem, what do you suggest should be the solution at this point?
This issue you have raised is actually a very vexed issue. So when just when Kama 2020 was passed, I was opportune to have been on the task force on corporate affairs commission set up by the MBA task force on corporate affairs commission set up by the MBA president, and we engaged with the with the Registrar General of CAC and other senior members of the CAC on this issue. So, like you rightly said, Monica, the argument of CAC was that simple. Kama 2020 no longer makes and in fact, they even argue that even Kama 1990, if you look at it carefully, nowhere makes the CAC a repository of share transfer information. That there's no positive section in the law stating that you must notify. For instance, you must notify a change of address to the CAC, but there's no law saying you must notify a transfer of share to the CAC, which is why the CAC came up with that policy. But and then of course the argument is also made was that when it comes to share transfers, it's essentially a private transaction. So it's just like you buy your shares, you need to of course pay stamp duty or whatever. So the argument was that if you need to show from documentation that transaction has happened, then you should be showing things like on your deed of transfer, you've paid the appropriate stamp duties, and of course the Federal Inland Revenue Service would stamp that would be enough evidence to show that the transaction had occurred. But I agree with you, Monica, that for me, thinking about it carefully, and I'm still of that opinion that I think maybe if the problem was from the law, then it means there should be an amendment that there should be a requirement for CAC to keep statutory information of share transfers, because if nothing else, it could easily become an engine of fraud. I set up a company, I take on liabilities and all, I transfer the shares to Mordecai, and I leave the company. And while somebody comes to do a due diligence on the company, still sees that my name reflects there as the shareholders, because that's what the last information, with the CAC shows. And then he goes ahead to transact with the company on that basis. And then later he's coming to enforce, and then he finds that, look, I was never even in that company. I agreed, of course, that is separate personality. So the person was dealing with the company and not dealing with me, Marx, as person. But we know that the society we live in, there's a large extent to which people deal based on the credibility of the human being they see, because even the credibility of the human being actually has an impact on the credibility of the company. So if I'm giving a loan to Dangote, for instance, I will not be giving a loan at the interest rate I give to other companies because of the personality of the founder or the floater or the shareholder in that company. So I agree to that there's a need to have the information of shareholders of the company transfer in shares also, very importantly, always on the record at the Corporate Affairs Commission, so that the public is always aware who has a stake in this company and who does not have a stake in the company. So I'd agree with you, Monica, that there's an issue there that I believe maybe at the next time there's an amendment should be sorted out.
All right, Imisi, can we hear your take on this, please?
I have a different position. I have no problem with provision of the law. Unfortunately, I didn't. By the time these issues arose, I didn't bother checking with the old law. Sometimes I think that maybe it's people that are in mainstream practice that need to do that. But if you need to apply something and get something done in house, then you just need to look at what's obtainable right now, and then you proceed. Right. So the new karma doesn't make provisions, and let me say, for the sake of this conversation, that I take Marx's word for it, that maybe the old one also didn't make that provision. So it was because we didn't register transfers, we did returns of allotment, whereas we know transfers are not allotments. So I think maybe I lean more on the side of the CAC in that respect, because it just shows like it's not a transfer, but we then always went to the CAC to record and file as transfers, whereas we were using forms for allotments, right? As if the company, and then we'll back it up with transfer forms and so on and so forth. Now, that has clearly been removed from the new karma. And then because we are used to a certain way of doing things, it's shocking. So it's shock value. That's what I think it is, how everybody has reacted to it. Everybody's shocked that, oh, we don't have to file transfers of shares anymore. Whereas from the beginning, even when you look at the nature of share transfers by themselves, they are private, right? The CAC is not privy to it, does not need to be privy to it. What the CAC needs to know is who holds shares and so on and so forth. For instance, you'll find that share transfer forms, are always recorded in their nominal values, and then for filing purposes, and then parties retain the proper documents, right? And it's because of, like I said, privity of contract. So the CAC does not need to be privy to those arrangements. However, the CAC needs to know who holds what shares. And maybe that's where maybe there's a bit of fogginess in some of our minds, right? Now, if I have a share transfer conducted, or a series of share transfers conducted in the course of a financial year, at the end of the year, my auditors are going to conduct an audit, right? And they're going to see what the true position is, right? I'm going to file my financial statement as a return at the end of the year. Those financial statements are going to show
It seems we lost Imisi there.
that there was, or there were, share transfers. The company, with respect to shares, to conduct their due diligence properly. If you go to the CAC and you conduct a full search, right, I'm sure you're going to be able to get the annual report of any company, because in any case, it's public record, right? At some point recently, I was faced with this issue of share transfer, and we engaged external solicitors to, complete the brief and all of that. And as part of documentation to effect the transfer, I got deeds of surrender relinquishment. Now, I'm a very, if the law writes it this way, if it doesn't make sense, we can engage the lawmakers and the regulators and so on and so forth. If we are not pressed for time, we can wait until that engagement is done. If we are pressed for time, we might as well, comply and continue with our engagement, right? So the question for me was, why would I be filing a deed of surrender or relinquishment when in fact what happened was a transfer of shares? And there wasn't any good explanation for that. And usually, sometimes as colleagues, we just feel, oh, what's going on in Nigeria, so this is the only way we can do it, that it will show, right, in CAC records that this has happened and all of that. So that might fly maybe with private individuals that are nationals of Nigeria, they are citizens. Right? But if you're dealing with institutional investors, foreigners, high net worth individuals, they know what they've done. They are not going to sign a document that says they've done what they did not do, right? So we had that issue because someone sent deeds of relinquishment and surrenders, to these former shareholders saying, please sign this. The issues you're facing are tax issues for them, because if you relinquish, you didn't gain, so you're not paying tax, right? So you're looking at tax issues for them, for which in some countries you could go to jail, right? So we went back to engage with the external solicitor to say, see, this thing is not working. Talk with CAC. And for some reason, they didn't flag that it is not the law. So we had to go look at the law and then understand that by the time you file your annual returns, you would effectively have filed your transfer of shares. Now, the reflection that we then have on the CAC portals to show who are the current shareholders of the company and all of that is now a gap for CAC to close. Because if I have filed my annual returns, then you should look at it. You shouldn't just upload it there. You should look at it. What has changed in my corporate structure that needs to be reflected in your records? So it is something for CAC to do. It is not something for lawyers to find a way around, because like CAC has said, right, and I agree with them, we don't need to file transfers. But CAC needs to pick up, and take up their own responsibilities to reflect the true state of things. Of course, to then make the cost of due diligence cheaper, because if you're doing a full dive compared to maybe just a preliminary, in case maybe what you want to do is you want to see whether you should even carry on conversations regarding investments and all of that, and you don't want to plow in so much money before you realize you're not even interested in going on, right? So it's something for CAC to deal with. It's not a real problem. It's not a real problem.
All right. Okay. All right. Thank you so much, Imisi. That was very, very extensive. Yes, I think from what I pick, I think companies who really want to be open about these things have a way to do it. File your returns and make sure that these things are captured. So if I'm trying to look at the company's records, I should also be looking at their returns to know who is still there and who has left. That's one aspect of it. That's one way that will definitely help. Well, we are out of time. Max, I want to ask you a question and I want you to answer it in 1 minute. Transmission of shares. Shares can be moved from one person to the other by operation of law. Do you think that shares can be attached in a judgment claim?
Yeah, that's an interesting question, but I think the answer is direct. Yes, they can be, because shares are also property, just like any other property. They can be taken in execution of judgment, and therefore shares can be transmitted by order of court in terms of binding order of the court. So yes.
All right. So why don't you see people trying to attach shares all the time? You see people in court, lawyers in court, trying to get garniship proceedings looking for this. Why don't they just attach the shares of the companies and then maybe shares of the shareholders, shares of the directors, and then take over the company?
Well, a lot of times the challenge with that is that, except maybe there are shares traded on public shares traded on the stock exchange, which are almost as good as value for cash. I mean, if you take execution of shares of a private company, I don't know how quickly you'll be able to realize that, because sometimes it can be illiquid. You're only waiting for streams of income to come when there's a dividend declared by that private company, which nobody can tell. So if there are shares, maybe in Dangote, for instance, Dangote Cement, which is a public traded company, then it's good as cash, because you can take execution, you can take it in execution and immediately sell on the stock exchange and get value. But the danger with that is that, what if you take over the shares when the share was trading at 15 naira per share, and then by the time you finish, you are done with the court process, 2 or 3 years after, you finally get a hold of the shares, the value have plunged to 20 naira a share. What do? Do you go back to court and say, well, only part of my judgment that has been satisfied, so I want to do further execution? So this can be some of the teething problems why people just want cash or assets they can hold instantly and get value from immediately. But yes, shares would be a viable means of executing a judgment.
All right, thank you so much. And I want to say one thing. This issue we're talking about on transfer of shares, I think it's a problem for only private companies. Public companies are not caught in that web. So that should be noted. So we have a number of questions here. Chijoki Ochogu asked, how do you explain the concept of shares to a layman? I'm not going to go to Marx for that. I'm going to come to Imisi.
Shares, layman terms. Okay, right. So I'll try. This is my best efforts, right? So let's say, oh God, right? Shares have rights, and those shares, those rights are rights that accrue to a person in a company. So the person is natural, the company is artificial, right? And as a natural person, you can only control or affect the control of the company by shares, right? So the company is separate from you, although you're controlling it to do what you want, depending on the quantum of shares you have, right? But the company is going to bear liabilities for your direction of control, right? So the company is separate from you. If things go well, you benefit. If things don't go well, you're shielded, right? There's the veil of cooperation. Uh, so I think, yeah, because to oversimplify it, we just lose the essence of everything. Right.
Okay,
It's a
Mordecai, I
difficult thing.
apologize. Mordecai, just allow me
All
to
right,
chip in one word there. I think one
all right.
simple way to say it is that a share is a unit of ownership in company. Maybe that would help. A share is a unit of ownership in a company. Maybe that would help a little.
All right. I hope
Yeah, it
I
helps
hope
us. It helps us. But whether
that
it helps
works for you.
laymen is a different question.
But Chijoke is not a lay person. I wonder why she's looking for the lay
Right. I'm sure
concept.
she has. I'm sure she
Okay.
has that question for the benefits of others.
Yes, and it's good. Then she also asked, also when we say 1 million shares, how do we explain that 1 million shares is different from 1 million naira? Well, like they said, share is a unit of ownership, and that unit can be worth any amount. In the
Exactly.
first instance, it depends on what the subscribers decide it is worth. They can say that one share is worth 100 naira and it is worth 100 naira. They can say one share is worth 1 kobo and it is worth 1 kobo. So whatever they put it. Then the time comes, that value that is placed at the first time that is imputed in the memorandum of association, that is what becomes the nominal value of the shares. Even when the share starts trading, if it was traded at 1 naira per share, then even when the company is listed on the stock exchange, start trading at 1,000 naira per share, the nominal value is still 1 naira. So if we're talking about 1 million shares, that means 1 million units of ownership in the company, like Imisi said. And then now that can be 1 million naira, depending on the value of each shares. So I hope that helps. I hope explaining it
It
that
could be
way
lesser.
helps.
It could be lesser than 1 million naira.
It could be lesser, it could be worth 1 kobo, it could be worth 10 kobo. You
Yes.
understand? It could be less, it could be more. It depends on the value that the subscribers attach to it at incorporation. That is it. And Michael Fowler is asking, how does one go about transfer of shares? Transfer of shares is basically a simple thing. It's just for the two parties who are doing the transfer between each other to come and say, hey, I want to buy your shares. We should understand that in private companies, there is a restriction in the articles. You can't remove that part from the articles. If you delete it, the law keeps it there. That places a restriction on the transfer of shares. But then there are times where that is allowed. So when it is allowed, what happens is that the parties who are doing the transaction will execute a deed of transfer. And when they bring that instrument of transfer, deed of transfer, however you want to call it, and then they bring that instrument of transfer to the company. When they bring it to the company can either accept or refuse. And then that's also subject to preemption rights, like I explained in my monologue. If there's a preemption right, if he was supposed to offer it to the other shareholders before selling it, and he didn't offer it, those other shareholders could decide to veto the deal, like we saw in the Seplat and Mobile case, right? That happened recently, where the federal government, due to their preemption right, decided to veto the transaction. And then the company could also refuse. They could vote and then refuse, depending on the situation. So that is the way it happened. So it's just a simple thing where the instrument of transfer is executed between the parties that want to do the share transfer, and then it is given to the company, who then approves the transaction, and then it is done. It is not so much of a difficult process, even though I know we spent a lot of time talking about the problem, which is a post transfer problem, not a problem that happens during the transfer. That will be it for today's edition of Lunchtime Legal Talks. This is the first edition, the first episode, and we're going to be having episodes each week. We're going to be having a lot of um, guests, and it's going to be an exciting time. I believe it was exciting, and I'm very grateful for Imisi and Marx for taking out time to be here. I know Marx is in the middle of organizing a conference, and Imisi is a very busy lawyer where he works. Marx was asking if you were going to want to talk about boardroom politics. Imisi pretended like he
Ah,
didn't hear. I know he
oh,
doesn't want
oh,
to.
well, that's it can be interesting.
Yes,
I
yes.
don't mind talking about it, but we are out of time. It can be
Yes,
interesting.
we're
It's
out of
oh
time.
god.
And I'll look forward to
let,
have
me, let me let me let me
both
just I mean, because of, and I think maybe I should just quickly say something for maybe 30 or 45 seconds, right? So because of how shares can be and the rights that are attached to them, sometimes you can hold a small number of shares, right? But that small number of shares, the right attached to them by private contract between the shareholders, can entitle you to some type of political power, such that the person who is even the majority shareholder, when you speak, he has to take serious consideration of what you've said, right? He may have the votes to, sway things around, but because of the politics of it, right? Performance. I mean, when you get into the boardroom, then you then see how shareholders are particular about what their money is doing, in essence, how their shares are performing, who's responsible for what, how they can help. Because although they are not directors, they don't manage the day-to-day running of the business. They know that there are instances where directors will run into, cul-de-sacs, and they have the network, the connection to, smoothing things over. Like maybe you have a contract to enter with Microsoft, and one of your shareholders is, I don't know, maybe a Dangote, right? Obviously, if there's a negotiation glitch, right, bring it to the board. Dangote is just going to say, oh, I'll speak with Williams, and he'll be referring to Bill Gates as Williams, just so that, he demonstrates some type of personal relationship and all that. So these things happen. At the same time, I mean, it's not always a win-win thing. Sometimes a win-lose thing. You might have a situation where came out from, and then it's always been in front of you the whole time. By the time things have materialized, you can only understand um, conversations, what was said, why it was said, who said it, why someone was angry, why someone was insistent on so and so type of report, so and so type of information. You can only then understand certain actions in retrospect. You didn't even know those things were going on in the first place, right? Someone can request the most ridiculous, smallest piece of information from you at the secretariat, something as small as, can you share with me the register of shareholders showing the history of shareholdings, and you don't know what they want to use that for, but they are entitled to that, right? And maybe they've just used it to see, okay, who am I going to try to buy out from this company? How much do I think I need to come up with to be able to drag all these people out together at the same rate, because you're going to be selling, you're going to be buying the shares from everybody at the same rate. So, those considerations. And these people will come into the boardroom, into the shareholders meeting room. And if you're not privy to those conversations, my brother, you're just there. You're just observing and understanding. You're enjoying the corporate. So, I mean, for me, it's the best business school ever, the boardroom.
All right, thank you so much. Thank you so much to our both guests, Max and Imisi. I look forward to having you. And to everybody who joined us, this to inform you that the next topic will be next in the next episode. We'll be talking on foreign participation in Nigerian businesses, and I will ask you to join. It's going to be very, very interesting. It's going to be engaging. And I'll please ask you to follow us on our social media page so you can get more information on this. The recording of this will be available on our Facebook and on our YouTube page. Part of it, snippets will be on Twitter and LinkedIn. So please do follow us so you can get information. You can also visit our website at mordecai.com to find out more information. It has been a great time having all of you, and I look forward to seeing you next week. Thank you, and do have a lovely rest of the week.